As a court, please, my lord, we apologize for the late start. We don't have an interpreter at the moment, my lord. Mr. Jonas is busy arranging for an interpreter in another court,
I see.
and he's not yet here.
Okay.
Maybe we can just, I don't know whether we're going to wait for him. He said it will be about 5 minutes long. I think he should be here any moment.
All right. Yes.
Yes, my lord. Yesterday, when we adjourned, there was a debate as to whether
Yeah.
Mr. Ramusipili can use photos
Yeah.
that were obtained pursuant to an investigation in the second docket, First Lawrence Cast 3751 of 2019.
Yeah.
We raised an objection. We subsequently had a conference with the defense regarding those photos, and Mr. Ramusipili has indicated that he will no longer be using those photos, subject to confirmation by him. However, my lord, we just want to sound a warning to my colleagues regarding the use of statements either in this docket 63610 of 2014 or in 3751 of 2019. There's a tendency to quote passages of statements in either of the dockets, but until now, out of this main docket, 63610 of 2014, and invite Brigadier Gininda to comment on what those witnesses are saying. We submit, my lord, that that is improper. You cannot use, as we've objected yesterday when Mr. Ramusipili was quoting passages from some statements and eliciting the comments of Brigadier Gininda. You cannot use inadmissible evidence in cross-examination. The only way, my lord, to use such statements is if the defense signal their intention to call those witnesses. But unless they do that, my lord, that remains hearsay evidence. And in this regard, we just want to briefly refer to the Handbook of Du Toit Criminal Procedure under cross-examination on page 22 to 54, when it deals with cross-examination and re-examination of witnesses. He writes the following regarding the use of inadmissible evidence, and he says, cross-examination based on inadmissible evidence is not permitted. And he then lists the categories of such inadmissible evidence, and amongst those categories he refers to an unproven document which the witness also cannot prove. And he quotes then the case of Howard versus Decker, Vetkop and Agencies, and Forwest Estate Pty Ltd and Sousa, 1971, volume 3, essay 937T at 948 E to H, we had a look at that case. It's an old case, 1971 case, and it's the decision of the then Transvaal Provincial Division. It was a civil case, but the principles are still equally applicable. And in the heading, it says, where the party against whom a private document, in this case a private document, was applicable, but the principles are equally applicable to a criminal case. Where the party against whom a private document, in this case a deed of sale, not complying with certain requirements, is sought to be relied on, has neither been admitted nor its authenticity proven, nor that the contents thereof are correct. Its contents cannot be used either as evidence or for the purpose of cross-examination. And proving the authenticity thereof, my lord, entails calling the deponent of that document to identify it. And in this instance, paragraph G, even though it was a private document, the court referred to in paragraph G, and we quote, the law in relation to the proof of private document is that the document must be identified by a witness who is either, one, the writer or signatory thereof, or secondly, the attesting witness, or thirdly, the person in whose lawful custody the document is, fourthly, the person who found it in the possession of the opposing party, and fifthly, a handwriting expert, unless the document is one which proves itself, that is either produced under a discovery order or may be judicially noticed by the court, or is one which may be handed in from the bar, or is produced under a subpoena, duces tecum, or is an affidavit in interlocutory proceedings, or is admitted by the opposing party. So in other words, my lord, the rules of admissibility of a document must first be satisfied before a document can be used in cross-examination. And this applies to all the statements in this matter, as well as the statements that were made pursuant to an investigation in Foslores Case 3751 of 2019. We don't want to disturb the flow of the proceedings by standing up and objecting every time. Hence, my lord, we just felt that we just need to bring this to the attention of my colleagues. Thank you.
Okokuqala-ke udaba lokuqala umshushu akhulume ngalo ukuthi-ke nanjengoba izolo-ke bekunale iy'thombe lezi zasepark uMr Ramsepile ebefisa ukuthi-ke abuze-ke ngazo kodwa-ke baye bahlangana-ke izolo-ke umshushisi nabameli bakhuluma wasesho-ke uMr Ramsepile ukuthi cha akasaqhubeki-ke ngalezo y'thombe lezo ukuthi abuze-ke imibuzo kuzona. Okwesibili-ke uthi nje ufisa nje umshushisi ukuthi-ke exwayiseke ozakwabo mayelana nokusebenzisa-ke iy'tatimende abantu bazo abangezanga noma abangabizwanga la enkantolo bazosho ukuthi iy'tatimende zabo, okusho ukuthi-ke leso statement leso asikabikho isiqinisekiso ukuthi-ke kukho-ke ngokomthetho noma ngokwendlela-ke okwenziwa ngayo enkantolo ukuthi kusetshenziswe istatimende bese kulindelwa lo fakazi ukuthi-ke aphendule kwistatimende ekungesona esakhe, futhi nomnikazi waso istatimende leso engabizwanga enkantolo ukuthi-ke azosiqinisekisa mayelana nalokho okubhaliwe kusona.
Yes, Mr. Ramsepile.
As the court pleases, my lord. My lord, I note the submission by my learned colleague, my lord. However, I cannot respond at this stage, my lord, because I did not go and prepare for that. I'm busy preparing for the application. If I need to respond, my lord, it will have to be tomorrow.
I don't understand. Yesterday we said you should prepare.
No.
Both of you. Or
No,
not
the-
even both, all of you.
No, the court said we can either discuss it amongst ourselves or prepare. Or prepare.
Yeah, that's what I said.
Yes, or prepare, not discuss and prepare.
How do you how do you prepare without discussing?
No, the discussion was whether is it necessary to prepare for this argument pending that I'm going to use the statements or not. But once we decided that I'm not going to pursue that line of questioning using those photos, we then decided amongst ourselves that preparation is no longer necessary.
I see.
Yes.
So you're saying, I don't want to prejudice your client. Did you want to use that information? Let's start there.
It is not material for my cross-examination.
Well, now, why did you bring it to court and...
My Lord, I specifically stated why I brought that information to court.
Oh, okay, fine. What was the reason, by the way?
My Lord will recall, I don't know which witness was it during the main trial. Reference was kept on mention of the park, the left 200
Yes,
meters.
yes.
And the court asked my learned colleague, Mr. Baloy, that it's imperative that the court has sight of the photos of the park and the surroundings. And in light thereof, my Lord, I think the following day, Mr. Baloy came and furnished all of us with disclosure regarding those photos and the album and the statement of the person that took those photos. However, my Lord, that was not pursued thereafter, and the court never inquired further. But then, as I was preparing, my Lord, like I said, I came across those photos, and it was just to remind the court that the court wants us for these photos. Is it also necessary now to have that witness come and testify to orientate the court as to the park that was searched by the community, by the first responders, where it is alleged that the intruders ran, which is 200 meters away from the scene. That was the purpose, man.
Yeah, it's obvious the court wanted to know if there were photographs of the scene. And the answer then, because it was silence, I thought no photos were taken.
It is unfortunate, but because we were finished, my Lord, with the photos the following day, after the court.
And you never brought that to the attention of...
It was never brought to the attention of the court.
Now the question is, do you want to use them, sir?
No, I'm not going to utilize them, my Lord.
Because I don't want it to be said
No, it won't be.
that you are being refused and your client is being refused an opportunity to use those photos, which were supposed to be part of his defense.
Yes,
Are you with me?
I am, my Lord.
Yeah.
And I did discuss it with him this morning to say I'm not going to utilize the photos because this was the context within which I was bringing it to the attention of the court. And he is well versed, my Lord, that I'm not going to use those photos anymore.
Let's hear your colleagues, Mr. Misi.
Thank you, my Lord. The prescription, which is of a blanket nature, my Lord, that the state seeks to impose on the defense with regard to the usage of certain statements, tends to be unlawful, and from where I'm standing, it's a bit rational because it does not take into account the provisions of the Law of Evidence Amendment Act number 45 of 1988, which amongst others stipulates that information that is contained in a document or information that is contained in a statement may be admitted on a provisional basis where the person who seeks to use that information undertakes to call the person whose property value the content of such statement lies. So the person who wants to use that statement can simply make an application to court and say, my Lord, may I please be granted the leave to use the content of the statement, because later on then I will call the person upon upon whose credibility the content of this document lies. There's nothing wrong with that, my Lord. That is just point number one. Point number two, my Lord, is the state makes a disclosure. Upon investigation, or let me actually start it here. The state receives a complaint that is investigated by police. The police go out and take statements from certain witnesses. Then the matter gets brought to court and there's a trial such as this one. And the state makes a disclosure. In the process, circumstances had arisen in these courts, and in certain circumstances may also arise. I've also done this as well. Then you go to the list of state witnesses. Amongst the list of state witnesses is a particular Mr. X, maybe he's witness number 5. And then they call the first witness. The state calls his first witness. And then the process of cross-examining that witness, who's witness number 1. And then you refer to the statement of witness number 5, who's also mentioned in the list of state witnesses. For instance, you come and say, Mr. Witness of Brigadier Gininda, the state is going to call Mr. X, who's witness number 5, who's going to say, amongst others, this and 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 this. I'm not even so sure, my lord, whether that is unlawful, because the person that has been referred to, who the defense believes that later on will be called by the state, is amongst the list of state witnesses. So there's perfectly nothing wrong with that, my lord. Unless if the state from the beginning indicates that these are the specific names of witnesses that we are going to utilize in trial, the rest we will not be utilizing. It is therefore upon those bases then we can approach the court and say, on the basis of the fact that the state is saying that they will not be utilizing this witness, may I then be granted leave to provisionally use the statement, because most probably this information is very important for the defense of the accused person. I may call these witnesses in our defense, and then the court provisionally then allows the usage or the content, the usage of the content of such a statement, my lord. But a blanket prescription that such documents cannot be used, my lord, I think it's unlawful and it has to be rational. What should actually happen is it should be a case-by-case determination. It should not be a blanket amnesty. I therefore do not align myself with the suggestion or with the application by my. I don't know whether it was an application, but I heard him saying that he was sounding a word of advice. I don't align myself with that advice, my lord. I may say from the bar that I'm not inclined to accept that advice. Thank you, Madam.
Okay. Yes, Mr. Ngomalo.
As the court pleases, my lord, before Mr. Ngomalo addresses the court, I was called by my client to indicate that, my lord, the application or submissions by my learned colleague, my lord, are one-sided.
What?
Are one-sided because, my lord, he tells me that Brigadier Gininda has referred to the statement of Absalom Zungu, which he says links accused number 1 and 2. Yet that Absalom Zungu, the state did not call, and they led evidence to that effect. The evidence of Magaleni, who's the deceased, who describes suspect B, which the state alleges is accused number 2. Also, that person was never called. We have not been furnished with the death certificate of that person. So what he essentially says is that the state may be making this application, but what is good for the gander, the warning that he sounds to us, he must also sound it to himself. As the court pleases,
Yes, sir. Mr. Ngomalo.
My lord, the use of hearsay evidence is governed by Section 3 of the Law Amendment Act 45 of 1988.
Is that true?
Sorry?
Is it true or correct to make that statement? That hearsay evidence is governed by the Evidence Act, Section 3 of Acts. That 45 of 1988.
There are various, I think there's about 7 requirements that must be met before one can.
Yeah, that's why I'm asking, is it correct to say hearsay evidence in this case?
It is,
Because according to what I understood from Mr. Baloyi, those witnesses are alive. In terms of the Criminal Procedure Act, they must either be dead or missing,
yes.
so that the court can find that in that instance, that evidence could be admissible in the interest of justice. But that's why I asked Mr. Ramsipiri yesterday, this gentleman who compiled the photographs, where is he? He's still alive. And he never answered me. Just said, oh, well, you know, I don't know. So I couldn't make a ruling then. Okay, go on.
No, I was also going to address the court on the basis that if the court is forewarned that the credibility of that evidence upon whose property value relies is going to be called, then that evidence may be provisionally
Yeah, quite. You're right.
admitted pending the calling of that witness. And in the event that witness is not called later, then that piece of evidence may be removed from the record.
Fine. I
That's
agree
how
with
I
that.
understood it.
Yeah.
So if the court in any proceeding, for instance in this case, is warned that the counsel is going to use an affidavit and this person is going to be called, then the witness may be cross-examined on the basis of the content of that affidavit. If the court is forewarned, then failure of the counsel in calling that witness that was referred to earlier, then that evidence is scrapped from the
Okay,
record.
fine.
That's how I understand the whole
Okay.
procedure. Thank you.
Yes, Ms. Mshola.
My Lord, yesterday when we adjourned, the court granted us the indulgence to discuss with the state regarding the status of the content of the docket 375. My Lord, we did discuss the status of that docket, and the state indicated to us that since it was discovered by the state to us and we are in possession of that information, it can be used by the defense. Secondly, my Lord, it is the duty of each and every counsel who is intending to lead evidence on a particular statement, if the author or the deponent of that statement is no longer alive, to inform the court and bring the necessary application in order to be able to use such statement when cross-examining, especially this witness who is the investigating officer in this court. As a result, my Lord, my submission is that since we have been given that permission to proceed, as the time when comes when the counsel intends to lead evidence on a certain particular statement, each counsel knows the procedure, my Lord. That's my submission.
Yeah, but I thought here we're speaking about photographs, documentary evidence. Is that not
Yes.
so?
Yes, my Lord. My Lord, the photographs, unfortunately, my learned friend has decided not to proceed with that. However, the state had indicated that if he wants to lead the evidence regarding that statement, he can still proceed, my Lord. And we also ask the state to make those witnesses available to us if the state is not intending to call them. And the state indicated that as soon as we indicate, the witnesses will be made available to
Okay.
us. Yes. Therefore, whenever counsel is or intends to lead that photo album, especially in my case, I will be calling that witness who took that photo album, and I will be using that photo album.
Is he alive?
He is alive, my Lord.
Where is he?
Mr. Kininda can get
Says
it.
Zuluini, Orugo.
No, my Lord, the investigating officer will be approached when we are about to lead that information to get the whereabouts of the witness for us. Because once the state has finished with its state case, he will make those witnesses available to the defense, and the investigating officer will get them for the defense. And then we'll be able to call them, all of them, my Lord. We are going to give them a list of all the witnesses that the defense intends to call. As the
Okay,
court
fine,
is.
no problem. Yeah, as a general proposition, this court is obliged. I've listened to the defense and even the prosecution. The gravamen of this debate is the fact that Mr. Ramsipidi wanted to utilize photographs which apparently are the result of an investigation by the state in another case. And I think Mr. Baloyi initially objected that, but after some time relented to say if Mr. Ramsipidi wants to use that evidence, which is documentary evidence, he may deal with it as he wants. Am I quoting him correctly?
That's correct.
Right. Now, as we all know, the Constitution is the premier law in our country. What Mr. Baloyi stated about hearsay evidence is correct legally, no problem. And also what Mr. Mnisi states about Section 3 of Act 45 of 1988, the Evidence Act which came into being 1961. I'm sure all of us were born. It's correct. But there is a rider here. I asked, how was this evidence acquired by Mr. Ramosipidi? And Ramosipidi said it was apparently discovered by the state before this matter was nullified. Is that not so?
No, it was during this matter, the current matter, not before Justice Maumela. It was in this trial.
Oh, I see.
Yes.
Is that so, Mr.?
Well, and I don't want to cast aspersions on anyone. The main disclosure regarding 375 was done during the trial before Judge Maumela.
Yes, I
don't
think I
remember
listened.
disclosing anything
That's it.
pertaining to the and as say my lord, we
No, fine. I hear you.
memory can sometimes leave us in the lurch.
Yes,
but
I listened to say this was discovered during.
Yes, but
I even said my predecessors.
yes, that is my recollection.
Yeah, quite. But it was not formally discovered at the beginning of this trial on the 17th of July, 2023.
No, 375.
Yeah, 375. I'm talking about 375.
Yes, was discovered
Was discovered.
during the proceedings that were aborted before Judge Maumela.
Yes, that's how I understood it. You don't agree, Mr.
No, I don't agree, my lord.
You were all in court. I wasn't here.
My lord, how can that be?
I was sweeping the floors when you were sitting with my brother Maumela. I wasn't there.
But my lord,
And you can agree
yes.
on this. You were there during Maumela's time. You were there, or you are here during my time.
But what the essence of my submission was that the question emanated from your lordship, not Justice Maumela.
Okay.
but his-
Otherwise, we'll waste the whole time. Yeah, okay, let me just settle it. In terms of our law, the Constitution, about Section 35, 1C of the criminal of the Constitution states that an accused person has the right to defend himself and to challenge the state's case also. Consequently, accused before court here, they have the right to challenge any piece of evidence. Like, for instance, because it has been discovered, that this court doesn't have to inquire as to how it was discovered, because it appears that in any event, Mr. Ramosipidi wanted to utilize this evidence of photographs or an album. And I don't want this case, wherever it goes, you say this judge never dealt with this exigency. So I'm dealing with it now. When you decide not to use it, it mustn't be said that I refused you the opportunity to use it. Okay? Because my finding, as I say, is that your client has the right to defend himself. And then in section 151(2)(a), at common law also, there has always been a right vested in an accused to call witnesses on his or her behalf. And that the Constitution recognizes this right in section 35, and also the Constitution now guarantees every accused person, as part of the right to a fair trial, to the right to adduce and challenge evidence. And this principle was reiterated in the case of S versus Duma. It's an unreported KZP case number AR 141/14. Where it was reported that it is an irregularity if a judge or a court denies an appellant or an accused person an opportunity to call a witness in defense of so fundamental a right that if that happens, it vitiates the proceedings in the sense that he has been deprived of a fair trial right. And this applies to all the evidence, documentary or even evidence relating to videos, photographs, and verbal recordings, all evidence. And this was also repeated in the case of Ugwebu versus the National Director of Public Prosecutions, case number 86184/201, which judgment was delivered by my late brother, Claessens, on the 28th of May, 2019. And at page 22, he says the court recognizes the right, and that this right is underpinned by a right to a fair trial, and entails that all available evidence, including evidence that would assist an accused in his or her defense, should be made available, all, irrespective of how that evidence was acquired or discovered. In S versus Maluleke, unreported case number CA and R 34/2013, which was finalized on the 1st of November 2013. The court at paragraph 60 confirmed that where the defense fails to call a witness whom he or she could have been called, it is open to the defense to request the state to make that witness available. And actually, to put it in its proper context, the state is obliged, if it doesn't utilize any witness or any document which pertains to a case in which the right to adduce evidence or the right to defend the state's case, that is by the litigant, the state is obliged to make that evidence available, whether it be, as I say, documentary, photographic, or through video material. So it's a legal question also that if the state is not in a position to call any witness, it is incumbent on the defense to do so if it so desires in order to actualize the right to a fair trial and to adduce and defend evidence in terms of Section 35 1C. This case is peculiar in the sense that this court finds that this evidence, which is apparently wanted to be used by Mr. Ramosepili, which pertains to documentary evidence of photographs which were allegedly acquired or taken in another case, it doesn't stop Mr. Ramosepili or any accused person to utilize that evidence, because the right to Section 35(5) 1C, in my view, it's more decisive than the right to the privilege which is supposed to be extended to any evidential material which is in the possession of the state. Because we must bear in mind that this evidence, we keep saying it's a case. It's not yet a case. 735, it's not a case. It's still an investigation. A case only commences when there's litis contestatio, meaning that it only commences after the state has placed or put a charge to an accused person and that accused person pleads. Only then does that evidence become evidence in the accepted way. Otherwise, still an investigation. So Mr. Ramosepili actually wants to use photographs which are pertaining to an investigation in another case. But I'm saying the right of his client to Section 35(5) 1C supersedes even the privilege which the state could claim or wants to claim. Okay. So if you want to use that evidence, sir, you may do so.
As the court proceeds.
Inkantolo kufinyeza ke ekushoyo ukuthi ke ayivimbi banika ivimbi umuntu futhi ke mayibheka ke nawo ke amalungelo umsola anawo noma eshilo ke yena uMr Ramosepili ukuthi akasaqhubekike nokusebenzisa lezi ayithombe lezi zasePark, ngoba inkantolo isho ukuthi kuse uphenyo lela ngoba yithombe ke lezi eyingekho la kuleli cala kodwa zingaphansi kwakhe u375. Kodwa inkantolo ithi noma kunjalo ke uma kuwukuthi yena ufuna uyisebenzisa inkantolo ayimvimbi ke, kodwa yena eshilo ukuthi cha akusayisona ke isifiso sakhe, futhi ukhulumile nawe ke Mr Ntanzi ukuthi ke akasaqhubeki nokusebenzisa lezi ayithombe. Kodwa kubona ke lokho inkantolo ithi ayimvimbi ukuthi ke angaqhubeka noma wena naye ke ummeli wakho ayinivimbi uma kukuthi nifuna ukuthi niyisebenzise.
Okay, thanks. Yes, Mr. Ramosepili, any further questions?
As the court pleases, my lord. That's it. Now, Brigadier, yesterday I had started on an aspect of the description given by various people that were in the house, in particular regarding accused number 2. And that description is contained in the statements that they made on the 27th of October 2014, and for some of them, they are viva voce testimony also in this court regarding that description.
Yes, my lord.
Kuyiqiniso ke ukuthi ke ubuza ke izolo mayelana ke nendlela ofakazi noma abantu ke abathi babona ngalelo langa abe bechaza ngayo ke bechaza yena ke umsolo wesibili kuyitatimende noma ke bekhuluma ke ngazo i27 ka October 2014. Yebo kuyiqiniso.
Now, yesterday I had started on the evidence of Nthabise Mokete, and I had paraphrased some of her evidence and invited you to comment, but I'd like to start today with a proper premise by not paraphrasing, but by reading from the transcript of her evidence and invite you to comment. And the evidence is contained in the transcript of the 26th of July 2023, and I'd start at page 25, which Advocate Baloyi says, yes, you may proceed, and Ms. Mokete. Now, there was a stage where there was a sound, a loud noise that sounded like a gunshot sound, a bang sound, like that of a firearm, whilst we were still in the car like that. Now I got shot. I then said to her that it is the sound of a firearm or a firearm that is being discharged. And Mrs. Mokete here, she's referring to Yolanda Nota that she was with in the car at the time. Should I proceed? Or you don't have your... Okay. Mr. Jones, they are printing it for you. And then Advocate Baloyi says, if you say you said to her, who are you referring to? Mrs. Mokete, I'm referring to Yolanda Nota. Advocate Baloyi, yes. And then Mrs. Mokete. Now there was a person that passed or walked past at the time that I was saying to her that is a sound of a gunshot. This particular person, as he or she was passing, that he or she went past running. In fact, he was running as he was passing where we were. Then Advocate Baloyi, you say he or she. Did you see whether it was a male person or a female person? Miss Mokete, he looked like a male being. He had a pair of pants, lean built in terms of the physique. Advocate Baloyi, now from which direction to which direction was this person running past? Miss Mokete, now when I saw this person, the person had already passed the vehicle and he was running towards the park.
Must I comment?
Yes, because the comment that I want to invite, yesterday you gave, when I gave this, like I said, it was not quoting verbatim. You then responded by saying, yes, this lends credibility to one of the confessional statements of accused number 2, because he had said that he ran away after the first shot was fired. And by then we were referring to a person with dreadlocks. So my question was that, are you saying that the person that ran out at the time with dreadlocks was accused number 2?
Yes, but my comment insofar as yesterday is concerned, my lord, was in reference to the statement made by her, not her testimony before court, because I wasn't here.
Uma bengiphendula ke izolo mayela nomuntu ke okuthiwa uyena kokuqala waphuma ke futhi egijima bekumayelana ke nestatement sakhe hayi mayela nobufakazi ke abethulile la enkantolo ngoba ke ngenkathi yena sikhuluma ngaye ke uNthabise Mokete ngenkathi ethula ubufakazi bakhe ke la enkantolo mina ngangingekho.
And the second question will be, the person that is described by Ms. Mokete after the firing of the first shot, he says it's a lean or slim person in physique. And importantly, she did not know where this person was running from, because as she looked, the person had already passed the car that she was in. Do you want to comment on that?
My lord, again, I was not before court. I can only comment insofar as what is contained in the statement. So it's a difficult situation to.
Okunye futhi ke akushoyo ke kubufakazi bakhe noma kushoyo ke yena ke uMiss Nthabise Mokete Mokete ukuthi ke uma esembona ke lo muntu umbone esendlulile emotweni ukusho ukuthi ke akamazi ukuthi waye qhamuka ngakuphi noma ke ephuma kuphi khona ongakusho kulokho. Cha ngoba ke ngangingekho nkathi ke ethula ubufakazi mina ke engikushoyo ngikhuluma mayelana nestatement sakhe hayi ukuthi yini ayisho la enkantolo.
But you wouldn't have any reason to dispute her testimony that she did not see where the first person ran away from after the first shot was fired.
I will not dispute her testimony if that's what was put before court, because I was not here, my lord. That's the essence of what I'm saying.
Uma ukuthi ke nkathi ela inkantolo wathi uma lo muntu lo oqala ke noma lo muntu ke nkathi ke kusho noma isibhamu siqhuma koqala ukuthi wayebaleka ephuma kuphi akukho ke ngakusho ngeke ngikuphikise ngoba ke kwakubufakazi bakhe futhi ngangingekho la enkantolo.
And at page 26 of the same transcript of the 26th of July 2023, it will be at line around line 17. Ms. Mokete says, as we were busy arguing with each other like that, there was another sound of a firearm that is being discharged. And Advocate Baloyi says, now this second sound of a firearm that is being discharged, it sounded as though it was now close to the vehicle. The sound was closer to the vehicle. And it says, Advocate Baloyi, I presume that the person that was talking, that the sound is closer to the vehicle is Ms. Mokete, but they wrote Mr. Baloyi. And below Mr. Baloyi says, yes, you may proceed, Ms. Mokete. Now, after that sound, the people that passed running towards the park in the same direction that the first person who passed running to. And Advocate Baloyi, I won't read that. We go to line 15. Mrs. Mokete says, now, as she opened the door, mind you, the people that we have already seen had run down the street. Then there was a third gun sound. Now, as she opened the door, I also tried to open the door because now the gunshot went for the third time.
We are both looking, but
Page 27, line
we are on 26.
6, 8, line 18. The way it says, now this second shot, go down. Yes. Yeah, that's one.
What's the problem now?
I think we're on page 26 now, Lord. Past page 26.
Oh,
You see from line 17,
Yes,
page
yes.
27.
Yes, I'm just going through it quickly, my lord. Yes, my lord, I see that, but if one looks at page 27 on top, that's the comment I can make. It starts by saying running towards the park, the same direction that the first person who passed running took.
So sorry,
the-
Brigadier, before you proceed, it will start from the last sentence on page 26 where Ms. Mokete says, now after that sound, two people passed running towards the park in the same direction that the first person who had passed running.
Indeed.
Well, just before Brigadier Ginina comments, we've allowed this cross-examination to continue, but the court will recall that at some point, I think it was Advocate Nisi objected to Brigadier Gininda giving an opinion and said he's usurping the function of the court. Now, here's evidence that is before court. Now, Brigadier Gininda is now invited to comment as to who is the person that is being referred to here. It's our submission that once evidence is before court, it's now for the parties to argue on the probabilities as to who the person is that is being referred to here. It cannot be left to the witness to then give an opinion as to who is the person that is being referred to here. At the end of the case, based on all the evidence that would have been tendered, based on the probabilities, it will be for us to argue as to who, in all probability, is the person that is being described here. It cannot be left to the witness, my lord, to give an opinion on that.
Le mbuzo ke ebuzwayo ke manje bekuke kwanenkinga ke ngaphambilini la khona ke uadvocate Mnisi ashilo ukuthi ke akusiyena ke ufakazi onganikeza uvo noma asho ke ukuthi ucabangani ngento eshiwo umunye ufakazi. Kodwa ke manje ngale mibuzwayo ebuzwayo ke la khulunywa ke ngabantu noma umuntu owayegijima ke eya ngase park, akukwazeki ke ukuthi ke kungalindeleka ukuthi kube ufakazi onikeza ngalo lovo. Kodwa ke ngaphambilini bekunenkinga ke uma bekunombuzo okanjalo.
Yes, Mr. Msipili.
As the court pleases, my lord, let me skip this part and go directly to what I said. My purpose was, I was just giving the background of the sequence as testified by Ms. Mokete. But the main point that I wanted to come to is on page 26, she has already given a description of the first person that ran away past the car after the first shot, that he was lean in physique. Now the descriptor of the two other persons that ran thereafter, it's contained on page 34, and that's the sole reason why I embarked on this exercise, my lord. Not even so sorry, I think I made you print the wrong page. It's not page 34. Sorry, my lord, it's not on page 34. It's from page 45 to page 46 of the record of the 2607-2023, my lord. And that reference will be at line 15 of page 45. And it is Advocate Baloy saying, you mentioned that the first person was a shot that rang off and a person ran past, and you described the person, you mentioned that the second shot that rang off and two persons ran past towards the park. Are you able to describe those two persons? And Ms. Mokete says, no, I remember the very first person that ran past was tall, he was not short, also with a leaner physique or a slimmer physique. And then Mr. Baloy asked, is that the first person who ran past alone? And Ms. Mokete, the very first one who ran past alone. Yes, and the other two, Ms. Mokete, one of them was not, big in terms of the physique. He was neither lean as well. He was of average height, and I remember that he had dreadlocks. And at line 17, Ms. Mokete stated that now this other one, who was slightly bigger in physique, they did not outrun each other. They almost ran side by side, even though there was, and with a demonstration of fingers and in brackets written, that there was one that was a little in front of the other, and the very one with the bigger physique had a hoodie on his head. And with that head as well, he was taller. He was taller than the other two that I have already referred to. And he was asked by Mr. Baloyi, yes, any other description that you can give, Ms. Mokete? There is no other description that I can give. So essentially, the person that she described as wearing a hoodie is one of a bigger physique, not one of a thinner physique, according to her testimony here. And then she goes on to say, and with that head as well, he was taller. He was taller than the other two that I have already referred to.
My lord, my comment can only, as I've said, I think yesterday, can be perhaps twofolded. One, that the three suspects that Ms. Nthabiseng saw is corroborated in the confession of accused accused 2, in that he says he ran away after I think 1 and 2nd shot were fired in the house. He went out. He then refers to accused 4. He leaves accused 3 inside according to the confession, and then accused 4 goes inside. So when he ran out to the car, that is according to the confession, my lord, he was running alone, and this is corroborated by this Nthabiseng, my lord. Thereafter, the second 2 people that Nthabiseng is referring to, my lord, identifies one person with dreadlocks whom it is alleged, my lord, or the investigation pointed that the accused 3, in terms of the investigation, is the person with dreadlocks on that specific day. Now, what we do not have, my lord, in the investigation is what accused 4 was wearing. The fact that the second suspect is described in the second grouping now as having a hoodie does not necessarily mean it's not accused 4, because I don't have a description and we did not find evidence indicating what was accused 4 wearing on that specific day, including accused number 1 and accused number 5. We can place them where they were, but we can't say, I don't have evidence to indicate what type of clothing was accused number 4 wearing on that specific day.
Lana ke uma echaza ke uNthabiseng uyasho ke ukuthi ke umuntu amshoyo owaye gqoke ke ihoodie uma emchaza ke ngomzimba uthi umuntu ke owayemkhulu ke ngomzimba engasiyena ke umuntu owayemncane manje wena ke uthini ke ukuphendula lapho. Lokho ke kuyahambiselana nento ebhaliwe kusona istatement sakhe ke umsolo wesibili ungathi ke egonyuluka ushilo ukuthi uma isibhamu siqhuma okokuqala waphuma ke yena wabaleka washiya ke ngaphakathi umsolwa wesithathu futhi ke nophenyo liyasho ke ngoba ke uma sechazwa abantu ke laba besibili abaphumayo ke omunye uyachazwa ke ukuthi wayena dreadlocks uphenyo lothiko esalenza lukhomba ke ukuthi umsolo wesithathu yena owayena dreadlocks ushilo ke nokuthi futhi ke uma esemshiya ke umsolo wesithathu ke ila khona ke umsolo wesine esengena ngaphakathi ke manje uma ekhuluma ke ngabantu ababili abalandela kamuva uNthabiseng lokho kuyahambisana ke naso istatement sakhe umsolo wesibili ukuthi ke uma sephuma ke manje kwaphuma kulandela umsolo wesithathu kanye ke nowesine ukuthi amchaze ke lo kulabo ababili ukuthi wayegqoke ihoodie anginabo ubufakazi yebo ngiyazi ukuthi wayekhona ke lapho bese indaweni zabo umsolo wesine anginabo ubufakazi ukuthi wayegqokeni ngokufanayo naye umsolo wokuqala ukuthi wayegqokeni nomsolo wesihlanu.
The only description of the alleged suspects, my lord, that is given by the witnesses is insofar as the person with the dreadlocks, where they describe the khaki or brownish jacket, Mr. Makeleni, I think we dealt with him, who identified or assisted rather in the identity of the second suspect, where he described the black hoodie, which is corroborated by Mr. Zungu. So those are the recollection of the description in terms of the clothing that I recall. I don't recall having evidence that points to what exactly accused 4 was wearing, my lord.
Futhi ke lana esinako ke noma ke ubufakazi ke esinabo ke ukumala nokuthi ke kwagqokweni yini ke egqokiwe lapho ukuthi ke yena ke uMr Makeleni owakelekelela ke nowasiza ke ngokuthi kudwetshwe le identity kit mayelana ke nalo owayegqoke ihoodie kanye futhi ke naye ke uZungu owakhuluma ke ngayo ihoodie eyimnyama kodwa ke ukuthi umsolo wesine wayegqokeni anginabo lokho bufakazi lokho.
So that's how I could comment on that part, my lord.
Ilakho ke ngakusho ke mayelana nalokho.
My lord, I just have one comment. I'm having a problem with the line of answering by the brigadier because he's making reference to my client. And there is no question that was asked by my colleague with reference to my client.
He's giving evidence,
To which question?
which is asked according to him. He's giving evidence.
I'm not happy.
It's a hypothetical situation. Listen to what I'm saying. If a witness testifies about 4 different people, and he says accused number 1 did this and this and this and that, and it is your client, should he now, because he's your client, not testify about what number 1 did? He must now jump and say number 2 and 3 did this and this and this and this. Is that how you're reasoning it?
My lord, I'll leave it like that until...
No. Let's debate it. Is that how you're saying evidence should be led?
It was with respect to the questioning by my colleague,
Yes.
Mr. Ramsberg.
I don't
stressing,
control-
he stresses the point.
Ale?
He stresses the point with reference to my client. Instead of answering the question, a direct question that was asked to him.
So they say you're stressing the point about his client.
No, my lord. If I may say, my lord, and this is what I'm saying, the question was put to me, and I started by saying a collaboration, my lord, which is contained in the confession statement of accused 2.
Yes.
And I'm saying, what is it that he's saying? It's not me. It's in the confession where accused 2 says as he ran out, there was accused 4 who went in. I'm not stressing it is contained there, my lord. And I'm saying if you take that context and you take it to what Mr. Ramsipile referred me to, insofar as Ms. Mukiti is saying, I'm saying there's a collaboration. And that is why I'm saying, because we do not know what accused 4 was wearing, one can think that possibly it was him who's wearing a hoodie. That's why I was going with my answer. But I'm simply commenting or responding because the question has been put to me. And I have to comment about these 3 individuals whom Ms. Mukiti saw. And I'm talking about that collaboration, my lord.
Sikona ke ukuthi ngiyagxila noma ngiyagcizelela ke kuyena umsola wesine kodwa ke umbuzo engibuzwayo ke bese ke manje ke kufanele ngikhuluma ke ngaso istatement sokugonyuluka esenziwa uyena umsola wesibili ngikhathanisa ke noma ngihlanganisa nakona lokho engibuzwa ngako kuthiwa yikona ekushiwo uMiss Mukiti ngithi ke uma kwistatement sakho number 2 uyasho ke ukuthi ke number 4 wangena ke ngaphakathi so ngihlanganisa labantu abathathu uMiss Mukiti akhuluma ngabo.
But Brigadier, if you listened to the objection by my colleague Advocate Baloyi, and hence I ran away from the passages that I was reading at the beginning and went for the description. I sought your description, your comment on the description as per Ms. Mukiti. Because Advocate Baloyi says, as to who Ms. Mukiti saw as the first person running, that is an argument that he will make at the end of the case. It is not your duty to draw inferences about the mind of Ms. Mukiti that this person that was running there, therefore exhibit H and JJ, Mukiti says it's that person. It's not her testimony. Hence, Mr. Numalo is not happy because you didn't answer even my question. You went on a drift to show that you can draw inferences, which is not your duty.
No, but my lord, that's not correct. I didn't even utter one word of inference. I was asked a specific question to comment about 3 individuals that Ms. Mukiti referred to.
Yes.
And my response was in relation to 3 individuals as per the confession of accused 2. So I don't understand where am I quoting it correctly, because the question from Mr. Ramsipile, it's in relation to 3 descriptions. I mean, the description given by Ms. Mukiti about 3 different people.
Yes.
And I'm drawing that inference from the confession of accused 2 that relates to 3 different people. How could I be? Because then I don't know how to answer it, my lord, because I was asked a specific question and I answered it in that context.
Ngibuzwe umbuzo othize, lowo mbuzo ke futhi ngibuzwa ke ngabantu abathathu uMiss Mukiti akhuluma ngabo noma ke abachazile ngase mina ke ngiya kusona istatement lesi sakhe ngithi senziwa umsolwa wesibili yilokho ke engiphendulile.
You see, you even use the word, you drew an inference from the statement of accused number 2. I was only asking you, because other witnesses have described the person wearing a hoodie as a lean or slim person, tall, slim. Ms. Mukiti describes that person as the one with a bigger physique. That's the invitation I was calling for you to comment on.
No, my lord. Again, I disagree. I think I was even fair to say, insofar as accused 4 is concerned, that I do not have evidence of what he was wearing on that specific day. But my response, my lord, was insofar as the 3 individuals that I'm being asked about, described by Mrs. Mukiti, I'm corroborating that with what is contained in the confession statement, not what I'm thinking or what I'm drawing or trying to think the investigation led me to. I was very specific to say this is what I'm being referred to insofar as Mrs. Mukiti is concerned, Ms. Mukiti, and this is what is contained in the confession statement of Mr. Mramsipili's client. It's specific. It's not an inference that I'm drawing. So my answer was based on those, my lord.
Ekuqaleni ngishilo ke ngaze ngasho ngathi angazi ukuthi wayegqokeni umsolo wesine kodwa ke uma ngiphendula umbuzo ngalabantu abathathu abachazayo noma abashoyo yena ke uMiss Mukiti ngase manje ngiyake ngihlanganisa naloko okubhaliwe kwistatement sakhe umsolwa wesibili hayi ukuthi ngicabanga ukuthi kodwa ke ngihlanganisa lokho akushoyo labantu abathathu abashoyo uMiss Mukiti kanye futhi naloko okubhaliwe kusona istatement sakhe umsolwa wesibili.
My lord, will be this an opportune time to take a short adjournment?
Okay. What's the time?
It's 27 minutes past 11.
Okay, 15 minutes.